Get ready. 5 seconds to go. Start. Learned counsel for the petitioner would argue that this kind of statement would clearly expose the status of the prosecution side, as they have not taken much care even in smaller issues, and therefore if this case is fully handled by the prosecution without an effective assistance from the de facto complainant side, then certainly justice may not be rendered, and therefore in that circumstances it triggered the petitioner to approach the court below and seek for permission to assist the prosecution. Stop. Per contra, Mr. R. Sekhar, learned government advocate appearing on behalf of the first respondent by relying upon the counter affidavit filed by the first respondent, he submitted that if the case was handed over to the investigating agency, that is CID Salem City, it was thoroughly investigated, and as has been rightly pointed out by the learned counsel for the petitioner, the investigation was done impartially and a charge sheet had been laid against the accused persons. When the prosecution has completed the investigation to the satisfaction of the de facto complainant and all the accused persons have been brought into book, the present apprehension on the part of the de facto complainant that unless the prosecution is assisted by the private counsel to be engaged by the de facto complainant, the prosecution may not complete the trial to the fullest satisfaction of the de facto complainant shall have no substance. In this regard, the learned government advocate would state that since the offence committed by the accused persons are triable by court of sessions, and therefore before the court of sessions it is only for the public prosecutor to lead the prosecution, and there can be no substitute for the prosecution even by way of rendering assistance by private sources. Therefore, the learned government advocate would submit that the order passed by the court below is not only justifiable but also sustainable, and hence the revision may be dismissed. On the other hand, Mr. S.K. Ashok Kumar, learned counsel, appearing for second and third respondents who are accused persons before the court below, has submitted that in the impugned order the learned judge has not outrightly rejected the request of the petitioner. He would further submit that in fact the learned judge has permitted the petitioner to file written argument on completion of evidence of both sides. What has been rejected by the learned judge is a proposal to engage a counsel by the de facto complainant petition to assist the prosecution in all other aspects. The learned counsel for the second and third respondent could also submit that the learned judge, after considering the legal position in this regard, especially in the context of section 301 as well as section 302 which section 225 of the code, has conducted that the petitioner is not entitled to assist the prosecution as a matter of right. Stop. In this regard, the learned counsel, by citing the very same decision, which has also been cited and followed by the learned judge in the impugned order. Stop.